Hello, and thank you for joining our webinar, Mitigating Workplace Risk with Cannabis Breath Testing. As part of our commitment to helping employers keep their workplaces safe and employees healthy, Concentra is pleased to announce that we are partnering with Hound Labs to bring their cannabis breath testing technology to your market in a limited release beginning May 15th. Our speakers today are Sammy Dabbs of Hound Labs and Tay Phillips of Ogletree Deacons. Sammy, Tay, please begin.
Thank you, Lynn, and thank you, Concentra, for having us today. We're really excited to get into the details for today's webinar. Of course, we'll do some introductions a little bit more than I are and our experience in the workplace drug testing industry. We'll talk about cannabis legalization, the unique challenges employers are facing today, especially in the state of Michigan. Why now? Why workplace drug testing in 2024? All about risk mitigation, deterrence, continued testing for cannabis, and then mitigating workplace risk, right? Why breath testing is a good tool for recent cannabis use, and updating policies. As you look at new technologies, how do you incorporate that into your workplace drug testing policy? Of course, at the end, we'll do some questions as well. So Tay, why don't you go ahead and give your own intro here as one of our industry experts on the panel today?
Yeah, thank you, Sammy, and thank you, Concentra, for having me. So my name is Tay Phillips. I am a labor and employment attorney. I work at a international law firm called Ogletree Deacons. We do any and everything labor and employment, and that is obviously very broadly defined to include anything that happens that is related to the workplace. So one of those subtopics within labor and employment is drug testing. And so I'm the co-chair of our firm's drug testing practice group, which I've joked with everyone really in the last 5, 6, 7 years has turned into the marijuana group. And so I spend an uncomfortable amount of time all day, every day, talking to clients about any and everything drug testing, any and everything marijuana related, and trying to help them to not only comply with the really, really challenging and rapidly evolving state of the laws, but as well as trying to think of business centric type solutions that can help employers keep the workplace safe while also managing employment legal risks as well. So that's a little bit about me, and I'm very happy to be here. Thank you all for having me.
Thank you, Tay. And I'm Sammy Dabbs. I'm our CRO here at Hound Labs with the breath technology. And today I'm not here to sell you on the breath solution. I'm here to give you insights and voice of the customer, what we're hearing in the marketplace from an industry perspective, from our customers and prospects on the issues they're having with their workplace testing program. How do they balance safety and fairness throughout their workplace? So I am not the lawyer in the room. I am not the scientist in the room, but I talk about cannabis with employers every single day. So I have a lot of insights here and have been heavily involved in lots of conversations as it relates to cannabis. So before we get started, here's a short disclaimer for you all. Number one, Tay is a lawyer. He's not giving legal advice on this call, but if you need him, you can call him directly after the webinar. The Hound Labs breathalyzer is also intended to detect recent cannabis use. It does not measure whether or how much a person is impaired. We get that question a lot. Oh, wow, a breath test. That must equal impairment. Well, here's the story. There is no universal standard for impairment for cannabis testing, so we certainly cannot provide you with an impairment test. But what we do at Hound Labs and what we do well is a very recent way to detect cannabis, only within the last 3 hours. This product is intended solely for use in employment, law enforcement, and insurance settings. It should not be used for any medicinal therapeutic purposes or for any federal drug testing programs, such as programs run by the Substance Abuse and Mental Health Services Administration, SAMHSA, the DOT, or the U.S. military. So quick disclaimer there before we go ahead and get started. Let's talk about cannabis legalization, Tay, and some unique challenges. Our audience here, unless you've been living under a rock, you know that cannabis is very legal across the U.S. You see a lot more green across this map than you do than ever before. The dark green states are those adult use legality states. The light green is medicinal use legality states. And the more and more we move forward here, the more and more green you see this turning year over year. There's a lot of trends we'll talk about as well. And as we're talking to employers, as Tay mentioned, every day about cannabis, really they're saying the tipping point has arrived. They're calling us and they're saying, what do we do about our workplace drug testing policy? We don't know what to do. Should we remove it? Should we stop testing for cannabis? Some employers have, but what does that mean for us from a safety perspective? So, zero tolerance is really no longer enforceable, is what we're hearing. Those urine drug screens for cannabis that can detect up to 30 days, not so practical in these legal states. So, Tay, I know you talk to employers every day as well about cannabis specifically and these state laws. What are the trends that you're seeing, or what are you hearing from employers?
Yeah, very similar to what you're hearing, Sammy, which is this is really complicated. It's really confusing. We want to comply with laws, but at the same time, we're very, very concerned about the safety of our workplaces. We are very, very concerned about people who could be impaired at work that could hurt themselves or others. We are very, very concerned about opening the floodgates to any and everyone who wants to walk in the door, whether they be in a safety or a non-safety sensitive job, who could be using any sort of intoxicating substances, but particularly marijuana. And I hear a lot of the concerns, and then inevitably I'll always hear the, well, what can we do? What should we do? And unfortunately, as this topic has evolved over the past, let's call it 8, 9, 10 years, it has become increasingly employee and individual friendly and very, very anti-employer friendly. And so the laws and the historical testing challenges have sort of met right at this one moment in time. And so I think that what I'm hearing from clients is we want to do something, but it just seems too hard with the historical testing technologies as they have been. So that's what I'm hearing, the same stuff that you're hearing, Sammy. But for once, right, we can actually respond to them and say, okay, I know it's been historically very difficult, but how about you think about more recent use testing now that it is available, and it can help you to check some of those legal risk boxes while also checking some of the business centric boxes.
Absolutely. And as far as federal legalization goes, today when we're talking about state laws, we're talking about your corporate workplace drug testing programs, not your Department of Transportation programs, things of that nature, and implementing the breath test. But any thoughts on federal legalization, Tay? We hear a lot about descheduling cannabis. What are your thoughts on that?
Yeah, so I always, whenever I'm asked that question, I always joke and I remind whoever is asking the question, remember in this country, we can't really get along on anything, much less something that could be a little bit controversial. So, kidding aside, I don't think there will ever be straight up across the board decriminalization, and maybe stated another way, full legalization of marijuana. It is currently on Schedule 1 of the Controlled Substances Act. Obviously, there's been some chatter about it potentially moving from 1 to 3. I think the most likely thing that would happen is it just moves to 2. But I remind employers all the time, just because it moves up or down the schedule list does not make it, air quotes, legal. And really, the primary impact with rescheduling marijuana is really more so for things like federal research, maybe FDA oversight, some of those items, and maybe like a marijuana company can put their money in a bank. That's really what rescheduling would primarily do. It's not necessarily going to change any of the employment related risks, and it's definitely not going to change any of the state marijuana legalization laws and some of the employment protection issues that we see on the state level. So I try and sum that up to folks by saying, ignore the rescheduling issue. It's largely irrelevant for employment purposes.
Makes sense. And even, if and when it does, our crystal ball is cloudy on timing, right? So I always tell employers as well is my crystal ball is cloudy, but if and when that does happen, our solution as a breath detection tool for recent use probably becomes more needed even at that time, right? You still need to mitigate workplace risk. So, talking more about employment protections, there's been some laws this year, 2024, that went live. California AB 2188 was a big one, along with Washington SB 5123. Can you kind of go through these laws, Tay? And I know we're hyper focused with Concentra on the Michigan rollout. May 15th is the launch date for Michigan across the entire state with Concentra. But these laws tell us something. So, can you let us know what these trends are?
Yeah, so before I summarize the laws, I always like to remind folks that remember that where we came from when it as it relates to pot, right? It's the legalization both for medical use and the legalization for non-medical use both originated in California, right? And so I always remind employers that with this topic in particular, marijuana, and then also really any sort of employment issues, whether they be marijuana or not, many times you start to see sort of a left to right march across the country as it relates to some of these laws. And so, in other words, I think that the California law and to a lesser extent the Washington law could signal perhaps some changes that could occur throughout the country, over the next 5, 10, 15 years. And so I always tell employers, always pay attention to what's happening in California because sometimes it can be a little bit of a peek into the future in other states. The California law, AB 2180, it really does two things. It, on the one hand, number one, it prohibits employers from taking adverse employment actions, so termination, rescinding job offers, whatever the case may be, based upon a positive marijuana test if that test tests for or detects marijuana metabolites. And I usually see people's eyes glaze over when I'm explaining that. Basically, what that means is if you smoke marijuana, and let's just say you smoked it today, it's going to metabolize in your body and it's going to hang out and stay in your body for a few weeks. And depending on the type of test specimen that is being used, and specimen being things like urine, hair, blood, oral fluid, et cetera, the look back windows of detection may result, and the metabolization may result in someone testing positive for marijuana a week, 2 weeks, 3 weeks, whatever the case may be after use. And so the first part of the California AB 2188 law, it prohibits employers from taking adverse action based upon positive tests if those tests detect for metabolites. So that essentially means no more urine specimens, no more hair specimens, no more oral fluid specimens in many instances and circumstances because those tests are going to detect metabolites. So that is the first issue that is raised by AB 2188. In other words, you got to find a compliant test in order to take adverse action. And a compliant test would be one that does not detect metabolites and instead only detects, air quotes, psychoactive THC. So that's what I call the compliant test part of the law. That is in and of itself challenging enough because you got to find a compliant test, right? For those of you who are watching this, Hound test is a compliant test, but that's the first challenge is actually finding a test that's compliant. The second part of the law, and this is the part of the law that is much more challenging for California employers, and this is also the part of the law that I want any employer in any state to pay attention to because the concept applies not only to California but also across the country. The second piece of California AB 2188 is it prohibits employers from taking adverse employment actions based upon off duty use of marijuana. So if you are smoking pot at your house on the weekend outside of work, that would be off duty conduct. And that is where a recent use detection technology becomes extremely valuable because the recent use detection is going to shrink the time period where someone could argue that they were off duty, and it's going to really call into question whether or not they are fit for duty and safe to work because of the very, very short look back window. Again, we're not proving impairment, we're not establishing impairment, but it's creating a very, very common sense argument that this person's not safe to work based upon the recency of use. And so the off duty conduct piece of California AB 2188, that is the much harder issue to deal with. But again, the shorter recency of use that we can detect, the harder it's going to be for any individual to be able to assert that type of claim. And so, again, I said earlier, this is where I want all employers in all states to pay attention to this. Even though not every state has quite as restrictive of a law as California does, many states do have marijuana laws that contain some type of employment protection provision, or as it relates to medical marijuana card holders, the possibility of disability claims. And then some other states have some other protections for marijuana. In Michigan, you have a pretty significant risk with medical marijuana card holders of a disability discrimination claim. And even though a disability claim is not quite as restrictive as a off-duty conduct claim like in California, the same concept applies with respect to recency of use and recent detection. And what I mean by that is, again, the shorter look back window we have, the better argument we're going to have to argue that someone is unsafe to work based upon the test result. And by doing that, we're going to be able to minimize our risks of disability claims, particularly in Michigan, or any sort of pot related claim. So that is a way longer explanation of the California law than was probably necessary. But I want everybody to pay attention to the California law, again, for two reasons. One, because it could eventually be a framework that it spans to other states. And two, some of the same general concepts that we want to keep in mind with respect to recency of use and detecting recent use to rebut against those protections in California, those apply in all states. And then a really quick word on Washington. The Washington law is very similar to the California law. However, two important distinctions. Number one, the Washington law applies only to pre employment testing rather than both pre and post employment testing like California. And then number two, Washington, the law there has a pretty broad safety sensitive job carve out, whereas the California law has no safety sensitive job carve out at all. So, anyway, long answer to a short question, but I always tell employers don't ignore state laws in other states because sometimes they do indicate where things may be headed in other places.
Thank you, Tay. That's super helpful. So not only do we have the legal matters, those employment protections, but we're also in a cannabis culture. We did a survey at Hound Labs, and in our recent survey of 500 plus individuals, this is a variety of states, a variety of industries, and employees who said they use cannabis at or before work. So what are they saying? 53% of them said they use cannabis daily. 86% consumed by smoking or vaping. What does that number tell us? Is they want that immediate high by smoked cannabis. And 48% are using on the job, during a break, or while working. These numbers were astonishing to me when I was looking at our survey. So it's something to look at as employers. As we're in this cannabis culture, the access is increasing. Removing cannabis from your panel is not the only answer any longer, right? Dropping THC from your panel is really turning a blind eye. I like putting this image on the screen here because it's a little like putting your head in the sand. We don't want to deal with the state by state policy, things of that nature. But our breath test has a way to detect a very recent use detection window, which is a more sustainable solution for your state by state policies, only detecting about the last 3 hours of past cannabis use. So instead of dropping it, implementing a more recent use policy is what we're hearing in the market. Those that have dropped cannabis, there are surveys out there. The National Safety Council put out a survey, and 53% of the surveyed employers who dropped cannabis testing are now seeing an increase in safety incidents and a decrease in performance. This goes back to the fundamentals of workplace drug testing. The fundamentals were to detect and deter drugs being used in the workplace. And so eliminating the number one positive drug, the number one drug of choice that your employee population is using is not the only answer. So figuring out a way when to test, how to test, and using the breath technology as a tool in your tool shed for cannabis detection is what we're hearing in the market. Tay, let's talk a little bit about employers being in a rock and a hard place. We talk to them all the time. You have the dichotomy between HR, safety. You have conversations every day, I'm sure, with these individuals saying, well, gosh, HR wants to remove it because we can't hire anyone if we're using a urine drug screen for cannabis, detecting 30 days past use. But safety, it's like, we can't stop testing for cannabis. Can you talk to us about some of those stories and those partners that you talk with often about cannabis and what they're doing about it?
Yeah, so I have a golden rule, right? Which is I feel like that lawyers shouldn't just talk about the law, right? Because I think that if you spend too much time lecturing clients on the law, it ignores a very, very, very important piece of every business, which is running the business, right? And I think that a good lawyer should always think in a business centric standpoint and try and help clients operate within the law or maybe skirt around the law in order to check all the business centric boxes. And so, to Sammy's point, when I'm talking to clients, it's not hard to recognize all of the different stakeholders in an organization and the goals that all of those various stakeholders might have as it relates to drugs, alcohol, marijuana, et cetera, et cetera. And so, for example, I oftentimes hear from the HR people, we want to recruit, we want to retain, we want to make sure we have as many applicants in our pool as possible. It's hard to hire people. And when we have people who we hire, we want to be able to keep them and retain them. And so we are concerned about marijuana testing because we feel like that we're going to lose good people. I hear from the environmental health and safety people, and they say, no way, no how, no chance can any human being ever smoke marijuana ever because it's unsafe. And we don't want people to be impaired at work, and we don't want to create safety problems. And then, sometimes you have left wing people who feel one way, right wing people who feel another way, managers and supervisors who just want to make sure that they have people who are coming to work and may be subjectively thinking about their good workers versus their bad workers. The list goes on and on and on and on. And so when I'm talking to clients, I always say, look, there is a business centric solution that you need to find. And perhaps recent detection and recent use and detection of that recent use is a solution that can check all of your boxes, right? Because I think that if we're thinking about recruiting and retention, if we're thinking about safety of the employees, if we're thinking about, you know, managing your legal risks while also not policing what people do outside of work, the one thing that everybody can agree on is we don't want people to be impaired at work, and we don't want people to be coming to work shortly after they've used marijuana. And so I always pose this hypothetical question to clients. If I told you that there was a solution that I think checks all of your boxes, how would you feel about that? And there's always a bunch of resounding head nods, and that's why I say, well, there is a solution that can do those sorts of things. And so I think that, Samuel, what you're saying is absolutely correct in that there tends to be a lot of very strong personal and professional opinions within an organization that are going to vary considerably. But I do think that elimination of people who are unsafe to work due to recent use or due to impairment is something that everybody agrees on. And I think it's very refreshing to be able to point them to a option that can perhaps help them to combat against those concerns.
Absolutely. Absolutely. So we've talked about all these issues, impairment language being introduced into laws, employment protections, no longer testing for THC metabolites. employee privacy concerns, recreational cannabis use is on the rise. Where does it all stop? And we believe at Hound Labs this stops with a way to balance safety and fairness with a cannabis breathalyzer as a tool in the shed for employers to mitigate workplace risk. So let's talk a little bit further about recent use. So we'll go over the specimen types here. Tay was talking about hair testing, urine testing, oral fluid. I'll give you just a little more detail. Again, not the scientist in the room here, but hair detection lasts up to 3 months. Typically in the industry, a hair test is known as really the lifestyle test. Most employers are using hair testing when they use it at pre-employment. So you see a lot of large trucking companies, highly safety sensitive oil and gas companies using hair tests to mitigate risk at pre-employment. They don't want to hire drug users. So they want that 90-day look back window in a hair drug test. Urine drug testing has detection up to about 30 days of past cannabis use. Urine testing, the DOT has approved. So Department of Transportation has urine testing. It's really been known as the gold standard because it's been around for so long, right? So detection up to about a month. Oral fluid up to 72 hours. So oral fluid detects past cannabis use up to 72 hours, and breath only this 3 hour period. So you're not going to detect something that John or Jane Doe did yesterday or the weekend. You're only going to detect what they've done very recently, not what they've done off duty on their own time, in some states completely legally. So Tay, anything else you'd like to add here on the specimen types?
No, other than I mean, I think sometimes employers they get so bogged down in yes no testing and specimens and science and all this sort of stuff. I think if you're thinking about this from an employment risk standpoint and from a business centric standpoint as an employer, you should be thinking about the windows of detection. And I think that is the most important thing for the business centric side and from the legal risk mitigation side. And frankly, the shorter that window, the better it is for legal risk avoidance and frankly, in my opinion, for business centric considerations.
Thank you. It makes a lot of sense. And there's a lot of tools in the shed. Breath is an additional tool. So what we say at Hound Labs when we're talking to employers about implementation of their policy is this goes right alongside your oral fluid or your urine test for other drugs, right? Hound Labs breath test is only for cannabis. So these other specimen types are great to ride right alongside the cannabis breath test during your random program, and we'll talk a little bit about that in the coming slides as well. So let's talk a bit about the solution in performing a collection. Again, May 15th, Concentra medical centers throughout the state of Michigan. They'll have our equipment, they'll have our cartridges. So let's walk you through a day in the life of those collectors in Michigan. So they'll log into this base station. The base station is our breath capture component. It also manages a completely paperless chain of custody form. So all donor information is captured on that base station for chain of custody. The cartridges are scanned into the base station for the specimen ID. This specimen ID tracks chain of custody throughout the entire life cycle of that specimen, all the way to the laboratory at Quest Diagnostics. So the collector will connect those cartridges to the base station. The collector will then provide a donor sample into the donor cartridge. At the same time, an air sample is being taken at the exact same time. The donor sample takes about 3 to 4 minutes for full breath capture. The base station will track throughout that entire collection experience. And once those samples are collected, the cartridges will then be compressed by the collector. They'll be packaged off and shipped to Quest Diagnostics for processing. It's standard LCMS processing at the laboratory, and results will be reported back based off of the account number information. So that's just a little step-by-step process of what Concentra will be doing in the state of Michigan throughout their medical centers starting May 15th. So now you have a little bit more about the breath technology and the solution. Let's talk about policy here. So, policies and cannabis testing methods now can be adopted for this new era of this cannabis culture. Use is on the rise, employment protections, tight labor market. Dropping cannabis is a risky alternative. So, as Tay was mentioning, how do you balance all of these business interests at the organization? Maintaining safety and productivity, deterring use, and providing a fair and objective way to test, to help recruit and retain employees as well. So, risk mitigation strategy in its entirety. Let's talk a bit about reasons for testing here that employers talk to us about on a regular basis. Really, that continuous monitoring, comprehensive program from hire to retire from a drug testing perspective. So many of you are likely doing reasonable suspicion post accident testing today. What I like to call that, as it pertains to cannabis, is the fire extinguisher method. If you're only testing for cannabis at reasonable suspicion and post accident, then you're allowing drug users on site, you're not deterring them from showing up, and then you're hammering it after the fact, right? So you're putting out that fire after the fact. And so, what we try and promote and what employers are really taking into is the random drug testing program from a risk mitigation approach. So, employers are saying they're incorporating a THC breath test not only during post accident and reasonable suspicion, but right alongside their urine random drug tests, their oral fluid drug tests for randoms. So, they're using that to deter employees from showing up having used recently. Another reason for testing that we see coming through as we're getting results from Quest Diagnostics is pre employment. I was pretty surprised about the pre employment results and employers coming to us and saying, "Hey, Sammy, we want to implement a pre employment test because we want to set the stage. We want to say you may not show up here having used recently, you may not use in the workplace." And I was like, wow, kind of seems to me like I thought this would be the IQ test. Is John Doe really going to show up to the pre employment drug screen? Hi. And they said, we want to reinforce our drug testing program and policy. So it's really enlightening talking to employers and how they're going to use this. Tay, have you talked to employers about any other reasons that you'd like to tell the group here?
No, I mean, I think, I mean, no. Every client I talk to about testing or marijuana, I always tell them, look, I mean, the ways in which you can, the ways in which you test, I'm sorry, not the ways, the times in which you test and to whom you test, that is a little bit of a business centric decision you need to make
Mm-hmm.
that matches what your goals are. But I also tell people that every there's a difference in the legal risk profile with the individual to whom you're testing. There's a much different risk as it relates to a safety sensitive job versus a non safety sensitive job. And the risk profile is also very different depending on the time that you test someone. So, a pre employment test is going to have a different risk profile than a random test, which will have a different risk profile from a reasonable suspicion test, and so on and so forth. And what I tell folks is, again, the reason why those legal risk profiles are different is because there is going to be a higher level of scrutiny for a safety sensitive employee versus a non safety sensitive employee as it relates to the possibility that they could be impaired. And then the the potential for there to be impairment due to, for example, observation of impairment that could accompany a reasonable suspicion test. That's obviously going to create a much different set of facts than with pre-employment random testing, et cetera, et cetera. However, what I tell folks is that again, when we think about those points in time and the people to whom we're testing, when we think about that as it relates to the look back windows of detection, as it relates to all these different specimens, and what those look back windows may tell us or what they may create an inference of, that is where I think that you, if you're using a recent use detection test, irrespective of who and irrespective of when that test is being administered, you get a little bit more data and can make a better educated guess as to whether or not that person is safe to work or not, with the shorter look back window of detection. So again, when you're testing and who you're testing, that's a company specific, decision that's perfectly fine for you to make individually. But I think that the recent use detection does help to provide more data in any type of test and for whoever is being tested.
Right. Makes a lot of sense. So, as we continue to talk about policy goals and considerations, to Tay's point, when will employees be tested? Decide what positions, right? Tay was talking, is it all safety sensitive? Are there non safety sensitive? What are the laws in your state? So, really, the upfront definition of those safety sensitive roles within your company. I think that's one thing that we're hearing a lot throughout the industry is ensuring that you have those conversations. Safety and HR are partnering to say, these are my safety sensitive roles. We deem these safety sensitive. Anything to add there, Tay, on when employees will be tested, safety sensitive versus non?
No, I would just add, and I should have added this previously. Remember that we're talking a lot about marijuana, and we're talking a lot about trying to detect the use of marijuana and testing for marijuana. I would remind every employer on here that you do not need to forget about the existence of some state drug test laws.
Mhm.
Now, Michigan is not one of them. Okay, just to be clear, Michigan does not have a state drug test law, meaning that you can test whoever, however, whenever you want from a testing standpoint. But there are some states that do have some restrictions and prohibitions on when people can be tested and who can be tested. So, an example might be in some states, you can't do random testing on non safety sensitive jobs. Some Northeastern states have that framework. So, as far as Michigan, when, who, how, that you have a full canvas and buffet of options in Michigan. But I do want people to realize that aside from business centric decisions as to the who, what, when, where, how, there are some states that do have a little bit more strict framework on
Yeah,
testing.
absolutely. And so, how policies will be adapted to include a recent cannabis test. Tay actually talks to many of our prospects and customers regularly about incorporating a recent use solution within their policy. So, Tay, I know some of those sentiments are you may not use right before or during work, and we're going to test you for it, right? So, is there anything that you want to highlight on how to incorporate this in their policy from a recent use perspective?
Yeah, I mean, I think so. You have your basic drug test policy, which, and I'm paraphrasing, don't use drugs, don't come to work in possession of drugs, don't come to work impaired by drugs or alcohol. We might test you in circumstances A, B, C, D. So, sort of the bones of a drug test policy. And I think that if you wanted to add into that, a paragraph doesn't have to be anything fancy, right? But a paragraph on, we might implement this different type of testing technology. And that's something that you might want to build into your policy. Again, doesn't have to be anything crazy, doesn't have to be multiple pages or anything, just a couple sentences or a paragraph that outlines the way in which we're going to test you.
And Tay does give a free hour to those that are implementing our solution of consultation. So keep that in mind. If you'd like to reach out after the webinar, feel free to reach out for that as well. So, how will company policies address a non negative result? So, you're an employer and you get a positive THC breath test. What do you do? What we're hearing in the marketplace is that now more than ever before, there are second chance agreements, right? So, these conditional employment agreements that are happening when employees test positive, it's not dropping the hammer in termination. It's okay, you're going to go into a follow up second chance agreement program. We're hearing a lot of those instances. And then certainly engaging with your medical review officer. So the THC breath test is a drug test. There are certain states that require MRO review. And so the standard best practice is to still incorporate the medical review officer based on, of course, locations, policies, how you want to implement this. But we always encourage you to talk to your legal counsel, certainly talk to your medical review officer as you're implementing the solution. A couple additional things here is How can cannabis testing be reinstated? So, Tay, I'm sure you get this question all the time. Tay, we've removed cannabis. We've had a couple issues. We want to reinstate it with maybe a more recent use tool. What are some things that employers should consider as they're doing that?
I think that, I mean, I know I just keep saying about it. I think that if it makes business centric sense to re implement and reinstate marijuana testing, then I think that you might have to modify your policies depending on if there has been some sort of change in the policy or modification of the policy due to you taking it out. There might be, if it makes business centric sense, some public messaging to your employees, notifying them that the testing is going to be reinstated, and if you feel compelled to do it, why it's being reinstated and how it's being reinstated. And I think there's also, just the other business centric considerations of how that's going to impact the workforce. I think that really most of those decisions need to be made from a management level, and just figuring out how best to roll that back out to the employees.
And I think that goes right into the next questions is how can companies educate employees about new policies? So really invest time during this implementation phase, ensuring that employees are aware of policy changes, things of that nature. At Hound Labs, we do have employee facing content. So always feel free to reach out for that employee facing content as well. And with that, I think it's time for Q&A, Lynn. So we'll let you back on stage here and see if we have any questions.
Thank you, Sammy. Thank you, Tay. We do have a few questions, and some of this was probably covered in your presentation, but it would be great to reinforce some of this information. And the first question that we have for you today is, when will the Hound Cannabis Breathalyzer be available and where?
Fantastic question. The breathalyzer is available now. So employers are implementing this across the nation. Concentra is implementing this at their medical centers throughout the entire state of Michigan on May 15th. So this is really the countdown to that May 15th, ensuring you're ready to rock for implementation.
Great. And can you say again how long it takes to collect a breath sample?
Yes, so the collection portion where the donor is actually breathing into the cartridge takes about 3 times, sometimes 4 minutes. But the important point is the donor can stop and start throughout that entire collection. So they're not breathing straight for 4 minutes, for example. They can take a break and continue on breathing. And that bar graph will tell them how much they have.
Thank you. Another question we have, are there specific reasons for testing that you feel are best aligned for the breath testing technology?
Yeah, so I mentioned a few during the presentation, and what we're hearing is certainly post accident reasonable suspicion. But our number one reason for testing today at Hound Labs is random testing. So, a deterrence mechanism post employment to mitigate workplace risk before an incident occurs on the job site. So, I'd say random testing. And then the surprising one, as I mentioned during the presentation, was pre employment, that employers want to reinforce at pre employment. You may not show up having used recently, you may not use in the workplace. So I don't know, Tay, if any of that resonates with you, if you would answer differently.
Yeah, I mean, I think there's two different ways to answer it, right? The reason, in terms of like what is the trigger point, random post accident, reasonable suspicion, et cetera, et cetera. And then, I mean, the practical reason is safety.
Yeah, safety. So, what we're hearing for those reasons, to your point, Tay, is safety in the workplace, but also on the HR side, tight labor market. They don't want to fire anyone. They're spending so much time training and recruiting. So you have safety, you have tight labor market. Then you also have, we talk to general counsels a lot that come to us and say, hey, we have a lot of grievances from positive past use cannabis tests. We don't know what to do about this anymore. We need more of a recent use test. So it's really those three parties, your general counsels, your risk folks, you have HR, And you also have safety that we talk to regularly.
And this question, I think, goes hand in hand. Are there certain industries or states where you're seeing high or early adoption of the cannabis breath testing?
Michigan is one of our number one states, so we're really excited about this rollout with Concentra. Certainly, states like California, Washington, those states that have the heavy employment protections. I've been actually very surprised. The state of Texas, not legal at all in the state of Texas, but employers want to implement because of the bordering states, right? They have legal states bordering. So that's from a state by state response. From an industry perspective, more of the safety sensitive industries, you have manufacturing, construction. We also have a lot of the entertainment groups, so large amusement parks across the nation. Casinos are really hot to trot on our solution as well. They need a recent use test to mitigate risk. So, more on the safety sensitive side, oil and gas, things of that nature.
And we have a specific question here from an employer. We're an employer who self collects oral fluid but uses a collection site for urine testing. Will your system be available for both employer and collection site testing?
Yes, so we are rolling out, as I mentioned, with Concentra May 15th for that collection site rollout in the state of Michigan to start. So, May 15th, state of Michigan. We do have pockets of other collectors around the country. Feel free to reach out to us if you're not in Michigan and you would like a collector outside of that network. And as far as on site, certainly if that makes more sense for you to have the solution on site, then employers are implementing it on site at their workplace as well.
And Sammy, which lab is performing the breath testing?
Quest Diagnostics.
Good. Well, that's all the questions we have for today. So thank you, Sammy and Tay, for an excellent presentation. And thank you to everyone who has listened in. We hope you found the presentation to be informative, and Concentra plans to bring you more information on this topic in the future. And this concludes our presentation.
Thank you.
Thanks, everybody.